Hello, everyone, and welcome to this month's podcast. This month is going to be a little bit different. We are focusing this month on BVI rather than Cayman. I'm delighted to be joined today by Ayana Hull, who's a new hire and heads up the Maples regulatory team in the BVI office. Welcome, Ayana.
Hi, Chris. Thank
Hey.
you.
No worries. And also joined by me is Ellen. Ellen's a senior associate in the team here and is dual qualified in Cayman and BVI.
Hi, Chris.
Cool. Okay, so this podcast, the initiative for this is on the back of a really successful trip that we did a couple of weeks ago in the BVI, where we met with a significant number of stakeholders, both private and public sector. There was a lot of interest in a few key areas, so we thought that today we would go through some of those key areas, obviously keeping it to 15 minutes as close as we can. And we've also included some slides. So those slides will be available in the resources link, and I think they're going to be in PDF format. So Ayana, I think probably over to you first, if we could just have a chat around some of the issues that were coming up, especially on beneficial ownership, and then Ellen will flick over to you for some CRS, and then Ayana, I think back to you for CFATF. So Ayana, if we could touch on beneficial ownership, I guess, just for the listeners, we've got a sort of wide variety of experience and background on beneficial ownership, but just on the very basic side, what is the beneficial ownership regime? And if you can just give us a quick overview of it, that would be great.
So, as we all would be aware, the government of the Virgin Islands implemented the beneficial ownership regime to reflect the jurisdiction's continued alignment with evolving global standards, including those established by the Financial Action Task Force. The beneficial ownership regime in the BVI is a regime where all BVI legal entities, which include BVI companies and BVI limited partnerships, have to file beneficial ownership information at the Registry of Corporate Affairs.
And then, Ayana, does that cover every entity? Or is it, I think there's some form of exemptions that clients were querying when we met with them a couple of weeks ago.
So in terms of those who are exempt from filing obligations, these would include companies whose shares are listed on a recognized stock exchange. They would include BVI commission regulated funds, but there are some conditions applying there. And also companies with shares held by banks and trust companies, act licensed trustees, or foreign trustees regulated for AML purposes. Some of the conditions that apply to these are that a contact person must be notified to the registrar. And if the registrar requires information from that contact person, the information must be available within 24 hours. The registrar will contact the individual directly, but will also send a notice to the company that they've provided contact to that person for the information required.
Yeah, okay. And the 24-hour requirement was a key topic of discussion when we were over there. So I think for any of the listeners, that is something just to be aware of, particularly if you're taking on a contact person type of role.
Yeah.
And Ayana, in Cayman and other jurisdictions, we do have a difference in beneficial ownership percentage, threshold percentage, versus, say, for example, AML. Are you able to just clarify what the relevant percentages is and who is a beneficial ownership under BVI law?
Sure. Under BVI law, a beneficial owner in terms of the natural person is the person with ultimate control of the company or the limited partnership. And that would be 10% or more of the shares or the voting rights or the ability to appoint or remove the majority of the board. Now, there's a distinction in terms of the 10% that's required to be filed and the 25% access threshold. So while you're only required to file up to 10% for the beneficial ownership, access to beneficial ownership information that can be had by the competent authorities, they have to meet a 25% threshold in order to obtain that information.
Yeah, and that's a really key point too, because the 10% aligns with AML, but on the access side, it then goes up to 25%.
25%. And I think it's different in Cayman, as you said.
Yeah, in other jurisdictions, I think it's different. So there are nuances with each of them, and the BVI is a 25% on the access side. Ayana, outside of legal entities, trusts, I'm assuming a beneficial owner is defined fairly widely.
Yeah, for trusts, it would be the settlor, the protector, the trustee, any vested beneficiaries, class of beneficiaries, and others who have ultimate effective control. And in relation to all of these, whether there are companies, limited partnerships, or trusts, where you cannot identify a beneficial owner based on the threshold, then the regime goes to identify the person that would be deemed the senior managing official.
Perfect. That makes sense. Lastly, because I'm conscious I've asked you a few questions, so I'll let you get into your rhythm. Just if you could summarize some of the key obligations, and then I guess the real meaty part is just talk about the legitimate interest access, so that listeners are clear on what the access is and who may apply for an exemption. That'd be great.
Okay, sure. So in terms of the key compliance obligations, I can break that down in terms of the legal entities, the beneficial owners, and the registered agent. Legal entities have to identify the beneficial owners, keep record of steps that are taken, ensure that the information is collected, kept, that it's adequate, that it's accurate, and it's up to date. That information must be filed unless the entities that we just referred to are exempt within 30 days of incorporation for a company, registration for a partnership, or continuation, or any change that is made to that information. And the records must be retained for 5 years after the beneficial ownership relationship ends. Where beneficial ownership information is not confirmed, then the legal entity needs to notify the beneficial owner. And if that information is still not becoming, then the entity has an obligation to notify the registrar within 21 days of the filing deadline. Beneficial owners themselves need to self-identify and notify any changes to the legal entity, and the registered agent has to take reasonable steps to verify the BO information and notify the registrar of suspected noncompliance. Now quickly to the legitimate interest access. We've had a lot of interest in that, and legitimate interest access is now live in the BVI as from 1st April. This year. The purpose of the legitimate interest access is to allow persons whose purpose is to investigate, prevent, or detect money laundering, terrorist financing, or proliferation financing, or any legal entity that is connected to a person convicted or of criminal proceedings, or where criminal proceedings are commenced against that person for money laundering, terrorist financing, or proliferation financing. Or if the person is an obliged entity under BVI AML regime that's carrying out customer due diligence or other AML obligations, then by obliged entity simply means a relevant person in the BVI under the BVI AML regime that's conducting relevant business. Legitimate access, as we just indicated, is subject to a 25% threshold, and not all beneficial ownership information will be available. There are some restrictions in terms of data protection. A misuse of information obtained is an offense and may lead to certain restrictions. The regime allowed persons, as from earlier this year in January, to apply for an exemption from disclosure of this beneficial ownership information under any legitimate interest access request. And these applications can be made where a case can be made out for serious harm like fraud, kidnapping, blackmail, extortion, harassment, violence, where you have children or other persons who lack capacity, or if it's in the national security range where there's a concern with national security or public interest, then you can have special reasons in terms of why information shouldn't be granted, such as sensitive commercial issues or ongoing legal disputes, or where there's confidentiality obligations. Where an exemption is granted, then the beneficial ownership information will not be provided by the registrar. And the fees are $50 per entity, up to 5 entities if you wanted to make that application. And each entity after that 5, then it's $10 for each additional entity. So if you have 10 entities, then you pay $50 for each entity. 5 5s are that's $250, and then the other 5 will be 10 each. So you pay up to a maximum of $300 for 10 entities. That's the way the math works with that.
Yeah, I'll trust you on the maths. So that, yeah, this is a really important point, right? Because we get a lot of users of different jurisdictions and BVI and Cayman, etc., all saying that the registers are now public, and public does have access. Well, they are public, but with a caveat that you do have to have a legitimate interest in obtaining access, and then there'll also be a tiny fee. So the exemption you mentioned, Ayana, too, we've seen lots and lots of interest on that, particularly for people in high-risk jurisdictions where there is a real concern around kidnapping or extortion. So,
That's right.
do connect with us on any of those. The last point, I guess, on this for Ayana, and just to demonstrate the sheer volume of work that's gone into beneficial ownership in the BVI, just a summary, I guess, if you can share any industry figures on where the jurisdiction's at in terms of information being obtained and compliance with the number of entities in the BVI.
I believe the week that we were on the road show, we were reliably informed that we were at 94%, and that we intended to be at 98% by the 31st of March. So it appears that the majority of the information has been collected for the BVI legal entities, which is great. I don't have figures as of last week, but as of the week before that, it should have been somewhere between 94 to 98%.
Yeah, so that's huge, right? The strain that's put on everyone in industry and advisors. So well done, everyone, and well done, government, for getting those figures that high, and hopefully they're now at around about 100%.
They should be at 100% now,
Yeah.
yes.
Okay. Okay, traversing from beneficial ownership to CRS 2.0. Ellen, do you want to come in and give us an update on that?
Yes, thanks, Chris. So a brief update on CRS 2.0. CRS 2.0 took effect in the BVI from the 1st of January 2026, with CRS reports under the new regime to be submitted to the International Tax Authority by the 31st of May 2027. So importantly, for 2026, reporting financial institutions must submit their 2025 returns under the previous CRS regime, whilst simultaneously collecting the new additional data points, which I will speak to in just a moment. So while simultaneously collecting the new data points under the CRS 2.0 regime, and those data points are required to be reported by the 31st of May 2027. So broadly speaking, the updates under CRS 2.0 expand out the data points that need to be collected and reported under the new regime. So some of the additional data points to be reported on include the type of account, so whether it's a new account or a pre-existing account, whether it's an equity or debt interest held. An additional data point is confirmation that a valid self-cert has been collected. And a further data point is whether the account is held jointly, how many account holders are on that account, if then the reportable person is a controlling person, the nature by which that controlling person, whether it be by ownership or control, or whether that person is a senior managing official. And under the new CRS 2.0 regime, the definition of financial accounts has also been expanded out to cover off crypto assets held in custody and other digital money products. So that's another key update that's been pushed through under CRS 2.0. And we understand the CRS being an international reporting regime that, Cayman has followed suit in terms of crypto assets being covered within CRS 2.0. So we're still waiting on updated guidance and legislation to be published on this point. So we will be updating our regulatory blog as and when updates are received from the ITA. But I just also wanted to quickly touch upon some general CRS points that would have been relevant under the old regime and continue to be relevant under the CRS 2.0. And this is in terms of registration. So really importantly, all financial institutions are required to complete a one-off registration process with the International Tax Authority, and that's through their BVI FARS portal. So that registration is by the 1st of April after the reporting FI becomes a reporting FI. And then, as I mentioned, that the annual deadline for CRS returns to be reported on is by the 31st of May each year. As I understand it, a recent development in the BVI from maybe around early 2025 is that now all reporting financial institutions must submit an annual CRS additional information form, which must be filed within 9 months of the end of the financial period for that FI via the BVI FARS portal. And the purpose of this additional information form is to ensure that the ITA obtains the necessary data to demonstrate effective implementation of the CRS, so that when external assessors come in to the BVI, that the ITA will be able to show the data points that have been collected under CRS. So the additional information form requires information with respect to reporting, reportable accounts and non-reportable accounts. So this will include financial account data, the categorization of account holders, whether the FI has policies and procedures in place. And this is also an important requirement under CRS, is that reporting financial institutions must have written AEOI policies and procedures. And if the ITA requests a copy of those policies and procedures, that then the financial institution must be able to hand over those policies and procedures, which will probably have an impact once the ITA kind of starts up desk-based inspections, which we would expect. I know on the Cayman side that we have seen a number of desk-based inspections. So I would imagine that in time that the ITA will follow suit on that side. Just one final point to mention on CRS more broadly, and it's also that the BVI has committed to the implementation of the OECD's crypto asset reporting framework. And I understand that information exchanges are targeted for sometime in 2028, but we will be bringing you further updates as and when we receive them.
Thanks, Ellen. Comprehensive. Good. The only part I was going to mention, it ties into what Ayana mentioned on beneficial ownership, is the new data points. So, for example, whether it's a joint account, and then Ayana, I think you mentioned for beneficial ownership, you now have to understand whether the BO, the gender of the BO, and I think it was the occupation too.
Occupation, yeah.
Yeah, so this is all going to mean a collective reach out to clients, whether as an FI and your account holders, or generally with a sort of holdco and your beneficial owners. So more engagement with clients, and Ellen, as you mentioned, more policies and more procedures, and expect the regulator to want to have a look at some of those policies and procedures in due course.
Yeah.
Ayana, it wouldn't be a regulatory podcast without some type of mention of FATF and CFATF. So can we close with you giving us a summary of where we're at on that?
The BVI is now ahead of schedule in several areas and expect to continue moving to meet the standards within a particular time period. There's obviously work to do in terms of the effectiveness of the regime. And the view of the BVI government is it's doing all that it can to get the BVI back within compliance as soon as possible.
Yeah, perfect. Thanks, Ayana. Good way to close out. Thank you both for taking the time. I appreciate you're both incredibly busy, and thank you, the listeners, for taking the time to listen. If you do have any questions, obviously connect with us or your normal Maples contact, or alternatively just hop onto our blog to see the latest and greatest for BVI reg. Thank you very much. As always, the contents of today's podcast do not constitute legal advice, and you should speak to an attorney at Maples if you do need legal advice, and it's a general update only.